Hello, everybody. I would like to wish you all a happy and prosperous new year. And once again, welcome you all to Lawputra's YouTube channel. So, today, the topic which we are going to discuss about is right to broadcast. So, in this video, we will be dealing with the following heads. As usual, I would like to define or explain the term broadcast before discussing the topic. What is broadcasting? So, in very simple language, broadcasting can be defined as instant dissemination of information through wireless means to the public at large. हम अपनी डेली लाइफ में रेडियो, टीवी और सोशल मीडिया का यूज करते हैं. इन माध्यमों से हम घर बैठे दुनिया के किसी कोने में घट रही घटनाओं का लाइव टेलीकास्ट देख सकते हैं. We can listen to our favorite songs and much more. Have you ever wondered how is it possible? It is all possible due to broadcast. Radio and TV are the twin broadcast media which have established themselves all over the world. The former as a means of transmission of sound and the latter as a means of transmission of moving pictures and sound. In the recent past, the word broadcasting has acquired a broader connotation to include data broadcasting. That is transmission of computerized data through wireless means, internet broadcasting, etc. Section 2, Clause DD of the Copyright Act defines the term broadcast as broadcast means communication to the public. Firstly, by any means of wireless diffusion, whether in any one or more of the forms of signs, sounds, or visual images, or secondly, by wire and includes a rebroadcast. Broadcasting developed as a result of early experiments in wireless communications conducted towards the last decade of the 19th century. Although Marconi is usually credited as the inventor of wireless, parallel inventions by several other pioneers working independently in other countries, including India, have contributed to the birth of wireless and its offspring, the broadcast media, that is radio and television. Now, who introduced broadcasting first in India? It was a Radio Club of Bombay. Broadcasting in India actually began about 13 years before All India Radio came into existence. In June 1923, the Radio Club of Bombay made the first ever broadcast in the country. Broadcasting is referred to as the central source of news and information across the globe. Due to this trait, it has a tendency of influencing the opinions of the public at large and is a target of illegitimate control. According to the Indian Constitution, broadcasting at present is a central subject, and the responsibility of overseeing broadcast service in the country rests with the Union government. Broadcasting was placed in the 7th schedule of the Constitution, dividing the subjects between the central and state governments. The Union government has created an autonomous corporation called Prasar Bharati and invested it with the mandate of providing public service broadcasting. The body that regulates and governs the media and entertainment sector in India is enshrined in the Cable Networks Act 1995 and the Prasar Bharati Act 1990. These are regulated by the Ministry of Information and Broadcasting in Prasar Bharati. Now, the next question which arises is the right to broadcast a fundamental right? The broadcasting develops as one of the fundamental rights provided in Part 3, Wide Article 19 of the Indian Constitution. It provides the right to speech and expression which directly reflect the right to publication and circulation of one's own views in the public with certain restrictions which are provided in the Article 19, Clause 2. Freedom of speech and expression broadly means opinions and own feelings expressed by words, mouth, writings, printings, pictures, or any other mode of communication. It includes the expression of one's ideas through any communicable media or visible representation, which is also called broadcasting. The freedom of propagation of idea is secured by freedom of circulation. It means every citizen has right to broadcast his article, book, painting, and own views through various broadcasting media like TV channels, FM radio, newspapers, magazines, mobile networks, etc. This right is also regulated by Supreme Court through its various decisions, which has also extended the scope of freedom of speech and expression. Further, the freedom of speech of investigative journalists working for television and the internet is protected under Article 19, Clause 1 of the Indian Constitution. Now, the very first question which arises is that under which case the court has recognized the right to broadcasting. In landmark judgment of the Secretary, Ministry of Information and Broadcasting versus Cricket Association of Bengal and another, delivered in the year 1995, it was held that the right to freedom of speech and expression includes the right to telecast and broadcast the matches, and this right belongs to the organization which cannot be interfered by anyone. The organization is free to choose any agencies or broadcasting media which it thinks appropriate to telecast the matches. Further, it elaborated that the primary purpose of all broadcasting media is only for the public interest. Airwaves frequencies are public property. The use must be controlled and regulated by public authority in public interest to prevent the invasion of this right. This decision resulted in a significant shift in the broadcast media's status, and the sector became more accessible to citizens. Now, I would like to throw upon some light upon the provisions in the Copyright Act 1957. The provisions relating to broadcast has been listed in Chapter 8 of the Copyright Act from sections 37 to 39A. Let's discuss the provisions in brief. As discussed before, Section 2, the clause D defines about the term broadcast. Further, Section 37 provides for the protection of the special broadcast reproduction rights of the broadcasting organization. This broadcast reproduction rights subsist for 25 years from the beginning of the calendar year to the next following year in which broadcast is made. Section 38 provides for the protection of the performance rights. Next, Section 38A provides for the exclusive rights of the performer, such as to make a sound or visual recording of the performance or to broadcast or communicate the performance to the public, except where the performance is already broadcasted. Moving further, Section 38B provides for the moral rights of the performer. Section 39 provides for the acts that do not infringe broadcast reproduction right or performance rights. And Section 39A provides for certain provisions to apply in case of broadcast reproduction right and performance right. Now, let's discuss the scope of broadcasting rights in India. In our country, broadcasting is one of the most important means of disseminating knowledge and information to the general public. Until recently, there were no strict restrictions governing the airing of content via television. The government of India had complete control over the broadcast media. Only commercial advertising and program sponsorships were done by private entities. So, India desired to establish a national regulatory framework to support its efforts and the common good. The Supreme Court ordered the government to establish an independent, autonomous authority that would be free of government control and maintain conditions that would allow everyone to enjoy meaningful and effective freedom of speech and expression. According to the Supreme Court, the right to freedom of speech and expression also includes the right to educate, to inform, and to entertain, and also the right to be educated, informed, and entertained. It increases the scope of the right to free speech and expression. The government has no monopoly on electronic media, and under Article 19, Clause 1, a citizen has a right to telecast and broadcast to the viewers through electronic media. Around the world, broadcasting is referred to as a central source of news and information, thus has a tendency to influence the opinions of the general public as a result of this attribute, and it is a target of illegitimate control. The Supreme Court has said in clear terms that using the airwaves to impart or receive information is a part of the fundamental right to freedom of speech and expression. This means that the government cannot use the airwaves as a matter of right. Fundamental rights are those of citizens, not of institutions or administrative systems. They may use it, but only if permitted to do so by a lawful authority. It also means that a right can be abridged only by the provisions of Article 19, Clause 2, that is, where security, public morality, or decency, and some other matters are concerned. In other words, access to the airwaves cannot be denied to a citizen except on these grounds. So ये जो कॉन्सेप्ट है स्पीच एंड एक्सप्रेशन का, इसका एवोल्यूशन हुआ विद द प्रोग्रेस ऑफ टेक्नोलॉजी एंड इट इंक्लूड्स ऑल अवेलेबल मीन्स ऑफ एक्सप्रेशन एंड कम्युनिकेशन. So this would include the electronic and the broadcast media. In the case of Odyssey Communications Private Limited versus Lok Vidyan Sangathan, the Supreme Court held that the right of a citizen to exhibit films on the state channel, that is Doordarshan, is a part of the fundamental right guaranteed under Article 19, Clause 1. In this case, what happened is a petitioner challenged the exhibition on Doordarshan of a serial titled Honi Anhoni on the ground that it encouraged superstitious and blind faith amongst viewers. And the petition was dismissed as the petitioner failed to show evidence of prejudice to the public. So this was all with respect to today's video. Hope you have understood it. Keep learning and keep smiling. Thank you.